how they have to split their properties and the custody of the children and all of these issues, then mediation will work wonder for this kind of situation. Real estate disputes are excellent for mediations. Again, a good real estate attorney that understands real estate law and all of the predicaments of real estate and contract law would be very, very good at explaining to the parties their situations and see if they can get them together. Almost all kind of litigation are subject to litigation. The only times that subject to mediation. The only times where it becomes very difficult if it's highly technical in nature, whereby you really need a lot of experts to tell us which side is right, whether it's technologically involved issues, like we're in the Silicon Valley, so there are a lot of disputes between these big corporations, whereby sometimes mediation is difficult, but not impossible. It depends again whether they can streamline the facts and issues and let the mediator work within them. Mediation is specifically effective, or very effective, I would say, when the main issue is money, other than maybe some sort of intellectual property rights or some more difficult issues within the legal practice that are present, whereby a mediator may not be as effective. Again, the mediator will help to narrow the issues, will show that he is empathetic, and most importantly, if he can provide different solutions or innovative solutions, whereby the parties may not have been able to discover without the presence of a neutral party that thinks outside the box, as they say.
I'd ask you to comment on this observation. I've heard it said that litigation is a form of warfare. Mediation is a form of reasonable people reasoning to a result. Is that accurate, somewhat accurate, not accurate at all, in your personal opinion?
Well, you're my professor. You said it. I'm not going to change anything of what you said. Right. You're absolutely 100% accurate, absolutely correct. Litigation is a sort of warfare. Mediation is a sort of reasonable people getting together and reaching reasonable solutions for their disputes.
And would you say arbitration sort of is in between litigation and mediation?
Yeah, I would say that. Or although arbitration is closer to litigation, formal litigation, than mediation. That's why I really favor mediation, because again, arbitration, it's all or nothing most of the time. I mean, when you go in front of arbitration, it's basically a mini trial. You present the evidence, the witnesses, you make your opening statements, your closing statements. You argue the case on behalf of your client. It is true that it is an informal setting, it is faster, it's less costly, but at the end of the day, it's a trial. And whatever results come out of this trial are final, and the parties are bound by it.
Have you experienced where mediation might then go to arbitration or trial?
Absolutely, and sometimes even though the mediation may not resolve the case, it makes the arbitration process even less costly and more effective, because hopefully, if the mediator has helped the parties narrowing the issues and knowing exactly where your weaknesses and strengths are by negotiating this issue between the parties, then the parties are much clearer at what their expectations can be. And sometimes, by the way, parties will agree prior to arbitration on a minimal and maximum award, regardless of what the arbitration results are.
Let's look at mediation. It looks like a particularly attractive way to resolve disputes in a very efficient manner. What's the basic process of mediation?
Excellent question. Generally speaking, the parties are invited together in the beginning of the mediation in the same room, whereby each party present their case. It's almost like an opening statement type thing. You present your case. You try as a mediator to avoid any direct confrontation or arguments between the attorneys and the parties. And at least everyone knows exactly what the other party is in terms of their position within within that particular case. Once the case is presented, then the parties are separated in different rooms. And then the mediator, through hopefully good listening techniques, will listen to the parties, will find out exactly what their position is, what is their demand, and will explain to them the risks involved within their position. In other words, the mediator is going to say, you know what, you may think this area or this fact or this law is going to apply, but if they can prove the other fact, then you are going to be in a weaker position. And then you shuttle that between the parties and you try to bring them together, and showing an awful lot of empathy, which is really critical. In other words, you try as a mediator to be in the shoes of both parties and just sit down with them, find out exactly, if I were you, what would I want out of this? What results would I want? And then you couple that with all of the other risks that they have. In other words, if you go to court or to an arbitration or litigation, you might get nothing. So a bird in hand. But again, I think what really impacts the parties the most is letting them know the pain they have to go through and the emotions they have to go through if this process continues. And you really dwell on the fact that, okay, today is the end of that dispute. You will never have to worry about it again. You go home and you live your life. And that's critical, by the way.
Well, I think diffusing the emotional elements and saying tomorrow you live again is a real critical thing.
You're absolutely right. It is probably the most critical, much more so, because again, and you explain to them the time value of money, that if you were asking for, let's say $100,000 in this case, but it's going to take you another year or two to get to that money, even if you win the $100,000 2 years from now, what is the value of the $100,000 today? And you explain to them the time value of money, and that accepting maybe 60 or 70,000 today is equal to $100,000 2 years from now.
And one of the complaints you frequently hear is, I got a $100,000 judgment, my attorney took most of it. And this is a process by which that also can be diffused. I know you're a good mediator. I've worked with you on some very difficult issues where you brought sanity to a situation, but I'd like you to tell the viewing audience, what are the elements that go into making a good mediator?
Again, some of what I'm going to say is basically going to be repetitious, but probably the most important one is being a good listener and listen to what the parties have to say. The second one would be empathy. I think empathy is a critical issue whereby a good mediator will try to be in the shoes of the other party and understand their position. Of course, experience, and I've been, as I indicated before, doing alternative dispute resolutions for years within the court system. I've acted as a judge pro tem and an arbitrator on a lot of cases, and a mediator in a lot of cases. And I'm happy to say that I've almost never failed in getting to some sort of a resolution between the parties. Being impartial, gaining the trust of the parties is really crucial. And again, you gain the trust of the parties by having good communication skills and explain to them the realities that are involved in litigation. Being optimistic and letting them know, the first thing I tell the parties is that today is going to be the last day you will ever have to deal with this dispute. And going in and letting them know and preparing them mentally to resolve their issues is sometimes critical. And again, coming up with being able to be being creative and understanding the business aspects of litigation. Again, as I said earlier, the time value of the money, and knowing that once you're done with this, you don't have to worry about it again. And you may take a little less than what you expected, but that money is available today.